Today's session from 3 p.m. to 4 p.m. Would be from Lay and Tran trial lawyers. And Stephen will be talking about enforcing foreign arbitral awards in Vietnam and reasons of refusal. Right. So, Stephen is a senior trial lawyer and founder of Lay and Tran. With years of extensive experience, Stephen has impressive litigation, arbitration, and criminal defense background, as well as his wealth of knowledge and deep understanding of how Vietnam's legal systems, courts, and authorities operate. So Lei Hoang Chuong or Stephen is the managing partner, as I mentioned. I'll invite you to now turn your webcam on and let's start this presentation. The stage, Stephen, is all yours.
Thanks, Rahul. Good afternoon, everyone. It's my honor to have a chance to work with the in-house communities. My topic today is about enforcing foreign arbitral awards in Vietnam, and we focus on the reason of refusal. On the screen, you can see my presentation today, and the presentation is focused on sharing experience and discussion. So the topic, there are two parts. The first part, I present about the basic condition for recognizing foreign arbitral award in Vietnam. And the second part, we focus on the reason of refusal. And there are many reasons of refusal by the courts in Vietnam, but there are four key common reasons. The first is about the residual pitfalls. The second about the signing capacity. The third about the violation to the arbitral procedure. And lastly, the conflict with the fundamentals of the law of Vietnam. Now we go to the first part, the basic condition for recognition of the foreign arbitral award in Vietnam. When you may often know the term that apply for the recognizing and enforcing foreign arbitration award in Vietnam. But I want to clarify that when you apply, there are two steps in the procedure of recognizing and enforcing of arbitral award in Vietnam. The first step is the recognizing by the Vietnamese court. And the second step is the enforcing the arbitral award already recognized by the Vietnamese court. So now the first part, we focus on the recognizing the foreign arbitral award by the Vietnamese court. And we don't focus on the enforcing of the foreign arbitral award at the civil enforcement agency. So when you heard some term about the recognition or enforcement of the foreign arbitral award in Vietnam, so you should know that that's the first step. Maybe some people, they misunderstand about the term. So the correct term is only the recognition of the foreign arbitral award. That's the most important step. So what's the condition for the foreign arbitral award is considered for recognition to be enforced in Vietnam? The first condition, that foreign arbitral award must be the final one. I know that in some international arbitration proceedings, there is the partial arbitral award. It means that it's only a part of the result settlement of the dispute between the party at the arbitration, and the arbitrator issue the partial award. But that partial arbitral award cannot be considered by the Vietnamese court as the final one, because the partial arbitral award does not stop the whole arbitration proceeding and settling the whole dispute. So the second condition for a foreign arbitral award to be considered for recognized is that arbitral award must close the whole dispute, and there is no further arbitration procedure at the arbitration center. And that arbitral award must be already effective. These are the three critical conditions for an arbitral award to be considered for recognized. Now, if you have any partial arbitral award and you would like to apply for the Vietnamese court to recognize, I'm sure the Vietnamese court will reject it, because the Vietnamese court will raise the principle that is the final one and fully settle the whole dispute. And this is also comply with the convention, New York Convention, 1958. that Vietnamese signatory to. And when you apply, when the foreign arbitral awards apply at the Vietnamese court, what the Vietnamese court will consider? The Vietnamese court will not review the content of the dispute, because the content of the dispute will be already settled by the arbitration center. The Vietnamese court only consider if all the formality requirements are compliant with the arbitration agreement, with the rules of the International Arbitration Center, and the arbitration law of the country that the party agree in the agreement, in the contract, on the arbitration law of the country where the arbitral award is issued. Many people may misunderstand that the Vietnamese court will review whether the arbitral award will comply with the Vietnamese law or not. It's not correct like that. It's not about the Vietnamese law. It's about the Vietnamese court will consider whether the arbitral award comply with on the law agreed by the party beside the law of Vietnam. Now we come to the second part of the reason of refusal by the Vietnamese court. Why many foreign arbitral award apply to the Vietnam courts are not recognized. At this time, only around 40%, 30 to 40% of the international arbitration award accept for recognized to be enforced in Vietnam. The first common reason is the residual defaults. Residual defaults mean that the judgment debtor or respondent, they are not informed about the arbitration procedure on time, or they have not had they don't have any chance to receive the notice from the arbitration center about any procedure of the arbitration center. This reason is more objective reason, not a subjective reason. The arbitration center can do the proceeding very well, and they follow the rule very strictly. But when implemented in practice, there is some small mistake, and that is the objective mistake, not subjective mistake. And so that the judgment debtor or the respondent, they lose the right. They don't have the chance to defend for themselves in the arbitration proceedings. Now we come to the example so that you can understand clearly. For example, a company in China, they request Vietnamese court to enforce to recognize an arbitral award in Vietnam, again a Vietnamese company. And the Vietnamese court reject because the receipt of the FedEx, the courier, did not specify the address of the receiver. On the receipt only state the name of the city and the country. And the document, there is no clear mention the checklist of the document was sent to the respondent. And the Vietnamese, the Chinese company provide the email address of the people that's assumed not from the people of the Vietnamese company. And the Vietnamese company disproved that they cannot identify who is the owner of the such kind of email address of the Vietnamese company. And there's the evidence. The evidence provided by the Chinese company could not prove that the arbitration tribunal did duly perform the arbitration proceedings. So these are the reasons on for example, the same example of the reason residual defaults. If you would like to know, you may see that this is just the brief for your understanding only. If you would like to know exactly how the reason of the judge and how the reason of the Vietnamese court on this bond, you should read the detail of the judge, of the decision of the Vietnamese court. For the second reason about the signing capacity means that the person who have the legal capacity or who has the sufficient authorization to sign the arbitration agreement. Either party to the arbitral agreement has no capacity or lack of capacity to sign the arbitration agreement. No capacity means that you lack of the physical or the mental capacity. And the Vietnamese court reject because the Vietnamese company, they respect the lack of authorization, or if the signatory is underage, a minor, something like that. For example, a company in Vietnam, I am the legal rep of a company in Vietnam. But when I don't sign the contract and I ask my vice director to sign the contract, but my vice director don't have the POA for me, and he signed the contract, and the opposite party also acknowledge that, okay, this contract is signed duly by Lee and Chen. But when go to the arbitration center and the arbitral award was issued, but when come to the court and the court see that I did not authorize to my vice director, so at that time I have a ground to request for the court to not recognize the arbitral award. So how to identify the capacitive legal definition? The Vietnamese court will base on the law of the individual who is the citizen, or if the signatory to the arbitration agreement is an organization, the Vietnamese court will base on the law of the law that's organization was established or licensed. For example, a company in Switzerland filed an application to the Vietnamese court for recognizing arbitral award against a Vietnamese company, and the court did reject because in Switzerland, based on the documents submitted by the Switzerland company, there are two legal representatives, but only one legal representative signed the contract. But instead, the contract should be signed by both legal representatives. And for Vietnamese company, the person who signed the contract with the Switzerland company is the deputy director. And the deputy director is not the legal representative of the company, and he having no authorization to sign the contract. So based on that, the Vietnamese court declared that the arbitration agreement was invalid. So when you sign in, but for the international corporation, when you sign the contract with the Vietnamese company for the cross-border transaction, you should very carefully check the authorized, the power, the capacity of the person who signed the contract with you carefully, whether he's the legal representative of the company or not. And even if he is the legal representative of the company, whether under the charter of the company, he has the right power to sign. Because under the Vietnamese enterprise law now, a company maybe have more than two legal representatives. So some people, you see that the director come the legal representative of the company, but in fact, based on the charter, he has no real power to sign the contract. He only have the power to sign the contract with the low value. For the critical value contract, the second legal representative will sign. So in this situation, you must check the charter and the business registration certificate of the company carefully to identify who has the power to sign the contract with your company, to ensure that there is no problem in the future, because the Vietnamese court will certainly declare the arbitration agreement invalid. Now we move to the third type of reason of refusal of the recognition of arbitral award in Vietnam. That is the violation to the arbitral procedure. For this type of reason, it may be similar. You may see that it may be similar to the procedural default as I mentioned in the first reason. But in the procedural default is objective reason. But now for this type of reason, it is a subjective reason. Subjective reason is mean that during the arbitration proceeding, a party, they are not invited, or their rights are not respected by the arbitrators or the arbitration tribunal, so that they lose the right to defend themselves. Either party has been deprived of the right to appoint an arbitrators or request the arbitration tribunal members, or either party has been deprived of an arbitration procedure during the arbitration proceedings. This means that the respondent or the judgment debtor want to join in the arbitration proceedings, but arbitrators, or maybe because of arbitration center, they did not perform duly arbitration procedure and not fair to the respondent. So this is considered as the subjective reason in the point of view of the Vietnamese court. So the Vietnamese court will base on the following legal base to consider if the arbitrators or the arbitration tribunal or the arbitration center violate the arbitration procedures. The first is the arbitration agreement between the parties. In the contract, there is arbitration laws, the dispute resolution laws, and the Vietnamese court will consider if the arbitrators or arbitration tribunal this follow exactly what the party agree in the arbitration agreement. For example, in the arbitration agreement, if the party agree that there must be the mediation procedure before bringing the dispute to arbitration center, the both party must perform the mediation procedure first. If the arbitration center receive the dispute and they discovered the party have yet passed the mediation procedure, so the arbitration should return the dispute to the party and request them for the mediation first. Only after they finish the mediation, the arbitration center will receive the dispute. Otherwise, if the arbitration center receive the dispute and don't follow the rule in the arbitration agreement between the party, the Vietnamese court will consider this is a violation to the arbitration agreement of the party and will reject the application for recognition. The Vietnamese court will base on the rule of the foreign arbitration center. For example, if there is an arbitral award from the Singapore International Arbitration Center, the Vietnamese court may also consider how's about the rule of Singapore International Arbitration Center to ensure that the arbitral award already comply with the rules. The Vietnamese court also consider the arbitration law of the country agreed by the party in the agreement, or the law of the country where the arbitral award was issued. So Vietnamese court not based on the Vietnamese law. The Vietnamese court will base on what the party agree and respect the agreement of the party first, and also respect the jurisdiction most relevant to the arbitral award. So some understanding see that if the arbitral award was issued not compliant with the Vietnamese law, so it was not recognized by the Vietnamese court. This thinking is wrong. Now we go for the sample example. A Switzerland company requests Vietnamese court to recognize an arbitral award against a Vietnamese company. The request was rejected because at the arbitration hearing, no representative of Vietnamese company summoned to the hearing. So that makes the Vietnamese company lose the right to defend or submit the arguments. For example, for some reason, the arbitrator or arbitration tribunal, they summon either party, but their summon was not cordial or not served to the respondent. So the respondent don't have any chance to be present at the arbitration hearing, and so that they lose the right. So the Vietnamese court will also consider this is a violation to the arbitration proceedings. For the last reason, this is a conflict with the fundamentals of the law of Vietnam. So this is very general. Most of the case rejected by the Vietnamese court will based on this reason. So what is the fundamental law of Vietnam? There is no clear definition. What is the fundamental principle of the laws of Vietnam? But in practice, you can base on the civil court of Vietnam, because the civil court is the general court clearly define the fundamental principle of the law of Vietnam. Based on that, the Vietnamese court will consider whether the arbitral award arbitration proceedings compliant with this principle or not. For example, the U.S. company and Korea company request the Vietnamese court to enforce, recognize the arbitral award against the Vietnamese company. And the court did reject because the court see that the party, the arbitration proceedings, and the arbitration tribunal did violate the principle of the free and voluntary undertaking agreement under the Civil Court of Vietnam. Because when settling the dispute, the arbitration tribunal did not consider the voluntary agreement stated in the contract by the party. or violating the principle of compliance with the law under the Civil Code of Vietnam. For example, when the party in the commercial contract, if the party agree that the governing law is the Vietnamese law, so when the arbitration tribunal consider the dispute, they must pay on the Vietnamese law to settle the dispute. They cannot base on other law. If they don't base on the Vietnamese law, they don't proceed to check the professional expert opinion on the Vietnamese law. This will be considered not compliant with the law under the Civil Code of Vietnam. So I have just finished. My presentation for the key reason of refusal of recognizing the foreign arbitral award in Vietnam. In brief, that is the four common reasons beside all the reason. Now I would like to talk more about the experience for the in-house counsel. As an in-house counsel, what you will do, because some in-house counsel are not the litigators and have yet had any chance to join in the international arbitration proceedings. So the advice for you, and when you have a dispute and you establish, you seek for the external lawyer for the arbitration proceeding at the International Arbitration Center, you should also find the support from the local lawyer. For example, if there's a dispute at the Singapore International Arbitration Center and you find a law firm in Singapore to support you, but the Singapore law firm, they don't know how about the Vietnamese court will consider the arbitral award, even if they win the they win at the arbitration. But when come to Vietnam and they don't know how the Vietnamese court will consider to recognize the foreign arbitral award, so the foreign arbitral award can be rejected, and all the investment you did for the arbitration, you will lose the money for the lawyer in Singapore to do the arbitration proceeding, and losing the time and other things as well, because that you cannot enforce. In the end, you cannot enforce the arbitral award in Vietnam. So along with the dispute at the International Arbitration Center, you should seek for the support from the local lawyer of the country where you see that the arbitral award will be enforced. The second experience I want to share with you, and in case that you cannot enforce the arbitral award in Vietnam, you may consider to enforce the international arbitration, the foreign arbitral award in other country, which also on the signatory to the New York Convention. For example, particularly for the big corporation like the state company or the bank who from the state of Vietnam, they have the international transaction around the world. So you may consider, if you cannot enforce the just foreign arbitral award in Vietnam, you can apply to enforce the foreign arbitral award in other country. So thank you for your listening. I finished my presentation here, and I want to come to the part of Q&A. So if you have any questions, please let me know.
Hi, Stephen. Thank you very much. That was a very good presentation, very insightful presentation. We have a question from the audience, and I'm sorry if this has been answered by you in the process of your presentation. The question is, what if the Vietnamese company was served with all the papers, but deliberately did not attend the arbitration hearing?
Okay, my answer is, the key point is, if the document was already served under the rules, under the agreement, and under the arbitration rules, everything in compliance with the rule of the arbitration center already, and you have the evidence to prove that you already served the document to the right arrest. And if the Vietnamese part did not want to attend to the hearing, so that's the mistake and the violation of the Vietnamese part. So just go ahead with the arbitration proceeding, because you already do your best in compliance with the rules of the arbitration centers, and you have the evidence.
Right. Thank you very much. We've just got another question, and I would encourage all the attendees right now, if you have any questions for Stephen, please go ahead and you can type the questions in the Q&A box. You can
I
also
see.
ask anonymously.
Yeah.
There's another question that has just come up. The question is, if both of Vietnamese companies choose SIAC arbitration in the contract, is the enforcement of the arbitral award likely to be acceptable to Vietnamese courts?
Yes. The Vietnamese court now is also advanced. As I said, the Vietnamese court only consider whether the arbitration proceedings and the arbitral award was issued in compliance with the rule of the arbitration center or the agreement by the party, not only with the Vietnamese law. So I think that if the two Vietnamese companies select the Singapore International Arbitration Centers for the dispute and want to apply for recognition and enforcement in Vietnam, it's okay. I think that it's also a good point because many people think that selecting the Vietnam International Arbitration will maybe better because both of company in Vietnam. So enforcing Vietnam arbitral award by the Vietnam International Arbitration Center may be better and easier than a foreign arbitral award from the Singapore International Arbitration. But it's not like that. Even you have the Vietnam Arbitral Award, but if the party dishonor the award, they still have the right to file the appeal at the Vietnamese court. And based on that, the Vietnamese court will consider whether the Vietnam Arbitral Award did comply, the rules comply, the formality requirements read by the party. And so based on that, the Vietnamese court consider to accept or to revoke the Vietnam Arbitral Award. So in the end, International Arbitration Center or the Vietnam International Arbitration Center, in the end, if they would like to enforce the arbitral award in Vietnam, they have to pass the gate of the Vietnamese court. But in Vietnam, it's better for the saving the cost and the money for you. I see the question.
Yep.
Yeah, I will take the question. How do we verify as to whether an employee of a Vietnamese company is authorized to sign an agreement with our foreign company? You should check. The first is whether there is a labor contract between of that employees with the Vietnamese company. The second is there must be the power of attorney because when do the authorization, there must be the power of attorney from the Vietnamese company to the individual to sign the agreement with your company. So without the power of attorney, absolutely, he has no power to sign the contract and the contract will be invalid. And another step you can check now, Vietnam has Vietnam have the public portal on the business registration. You can come to the public portal of the Vietnamese government to check about the information of the company, who is the legal rep of the company. If you see that the name of the legal representative of the company is different from the name of the person who signed the contract with you, you should raise the question to the Vietnamese company. I see the difference between the legal rep and the person who signed the contract with my company. So can you explain? And if this is your authorized person, where is the POA and where is the charter of the company to prove that he has the right power to sign the contract with your company?
Thank you very much. Again, I'd like to encourage all the attendees. If you have any questions, this is a very good time. Stephen is answering a lot of very important questions and not charging fees as of yet for answering these questions. So you have you have an expert on your hands. So Stephen, I've got some questions for you. If you'd like to answer, the first question that's come in is partial arbitral award considered for recognition in Vietnam?
Yes, this question I already advised at the first slide. This is a very important question because in my experience, I have already have to apply for recognition many arbitral awards in Vietnam, including the partial award. When submit to the Vietnamese court, the first question the Vietnamese court will question you if this is the final arbitral award to close the home dispute or not. If the answer is no, this means that this is a partial arbitral award and the Vietnamese court will reject, regardless how you reason. How is you reason in the end, the Vietnamese court will reject, because I honestly I failed many cases already. I learned a lot, so this is the truth I want to share with you. So the arbitral award must be the final one, and it settled the whole dispute, and there is no further arbitration proceeding anymore. And the arbitral award must be already effective. These are the three critical conditions for the at the outset for the Vietnamese court to receive your application to consider to enforce in Vietnam.
So I think, Stephen, there are some questions that have come in the Q&A box. Would you like to take them?
Yes, for the question from Yip Nguyen, how do we know if the customer foreign organization need more than one legal representative to sign on the contract to avoid that the signed contract is invalid due to not enough authorization? Is it not that easy to explore, right? No, it's easy to explore now. Even in my litigation court, when I submit the statement of claim to the court will request the charter of the company and the business registration certificate of that company as well. So you can apply the same tactic. When you sign the contract with the foreign company and you don't know whether the person signed the contract with you have enough authorization or not, you should request them to provide the charter of the company to you, or the business registration certificate to you for your verification. And if for some reason they say no, or they delay providing these documents to you, so you have the right to suspect, and you can do the further check by the public resource. For example, when I in some transaction with some Singaporean company, I often come to the business registration portal of Singapore, BizFi. I submit some fee to the organization and I check the information of the company, and I will discover who is the legal rep of the company. And based on that, you can make the cross check and do the examination with your customer. So I think that is not difficult nowadays. For the second question, is there a recommended arbitration forum for Vietnamese company that the Vietnamese court are more welcoming with regard to enforcement? I think that I don't have any recommendation to you, but based on the reputation and the trusted in my experience, I see that in Vietnam International Arbitration Center is the best in Vietnam now. So you can trust them. And for the International Arbitration Center next to Vietnam, that's in the Singapore. So I think that these are the two reputable and more acceptable by the Vietnamese court. Because why? Because the arbitrator are the expert who know the proceeding very well, and the successful rate of enforcing arbitral award from these arbitration center are also higher than other arbitration center in Vietnam. I have the arbitral award from the Vietnam International Arbitration Center. The arbitrator there are very good, honestly. They do everything very well and professionally. And I have just successfully win a case, and I request the court to the respondent file a appeal to revoke the arbitral award. But at the court, I also won the case for my client as well, and the court accept that the Vietnam arbitral award from the Vietnam International Arbitration is very compliant with the law and no route to reject it.
Right, thank you very much. I've got a question for you, Stephen. How are the formal requirements critical for recognizing the foreign arbitral award in the Vietnam court proceedings?
Yes. Vietnamese law system, particularly for the Vietnamese court, they refer the formality requirements as the first condition. If only after the formality requirements are satisfied, they will focus on the contents of the dispute. and because that this is the mindset between the two legal systems. Vietnam is not only the civil law system. It's like the it's like the it's quite different from the common law. For example, even now Vietnamese court they don't use email in communication with the plaintiff and the defendant. All the documents submitted to the court must be in writing. Even the photocopy and others, they don't recognize the validity of the photocopy as well. So, in comparison with with the development of the world, Vietnam is still at the back because they focus too much on the formality requirements. That's the reason why there's many lawsuits. The plaintiff lose because of they cannot satisfy the formality requirements. That's the reason why I advise you when you enter into any transaction with the Vietnamese counterpart of Vietnamese company, or the Vietnamese company want to sign the contract with the foreign company, all the formality requirements should be checked carefully. For example, like the authorization. Legal prep in some company abroad, they have many directors. So if some of directors sign the contract for you, but he don't have any power, so that's the problem as well in scale up any dispute, and vice versa for the Vietnamese company. If a foreign company want to sign the contract with Vietnamese, want to sign the commercial contract with a Vietnamese company and don't check who is the legal rep of that company, that's also a topple on the formality requirement. So before doing any transaction, should be carefully check the formality requirement under Vietnamese law, and so that all the formality requirement under Vietnamese law are satisfied.
Great, thanks for that. Another question. What are the statute of limitations to apply for recognition of a foreign arbitral award in Vietnam? I'll repeat. What is the statute of limitations to apply for recognition of a foreign arbitral award in Vietnam?
It's around 3 years. It's around 3 years from the day the International Arbitration Center the Foreign Arbitral Award being effective. So almost around 3 years. So you should, when you want to enforce your arbitral award in Vietnam, you should pay serious attention to the statute of limitation. Because some case the time is too long, you already have the arbitral award, but you miss it, you forget about the statute of limitation, and you bring it to Vietnam to ask for recognition. But the respondent just submit the route that is already over the statute of limitation. So he did nothing and win the lawsuit from you.
And the arbitral award of the Vietnam Arbitration Center more acceptable for being enforced in Vietnam?
In reality, we can say so because the Vietnam International Arbitration is in Vietnam. But if either after that arbitral award effective in Vietnam, and either party has no appeal to the Vietnamese court to revoke the arbitral award, it can be enforced easily. But in my experience, when either party lose at the Vietnam International Arbitral Award, they often file an appeal at the Vietnamese court to revoke that arbitral award. And for the Vietnamese court, they will also follow the rules to review the formality requirements. They don't review the content of the dispute anymore. So the rate of successful is higher because that most of the arbitrator in the Vietnam International Arbitration Center, they are also the lawyer in Vietnam. They know how the formality requirements in Vietnam under Vietnamese law well. So that's the reason why they can protect their client well in scale up the case go to the dispute at court. One more question. If a dispute is resolved by a foreign arbitrator, but Vietnamese law stipulate that the dispute can only be resolved in court, will the foreign arbitral award in this case be recognized and enforced? So your question is so general. Because I said the Vietnamese court don't review the content of the dispute. The Vietnamese court only review the formality requirements and whether is there any contrary to the fundamental principle of the Vietnamese law. So in this situation, you need to clarify why the dispute can only be resolved in court. Can you reason? Because for the commercial transaction, most of the commercial arbitration center, if the party agree, will have the jurisdiction. I have no idea why the dispute must be settled by the Vietnamese court. And even if the dispute for any reason must be resolved by the Vietnamese court, you must prove that that's the only option. But up to now, I don't see in my experience up to now, I don't see this situation before. So I see that this may be the theoretical version. That's the real version. That's in my opinion.
Great. Thank you very much. Right. We actually have a couple of poll questions. Stephen, is it okay for us to run some of these poll questions?
Yes. Thanks,
Okay.
Ron.
So this is for all the attendees right now. We're going to be sharing a couple of questions. They will appear on your screens, and you will have about 20 to 30 seconds to answer this question. And then we'll share the answers on the screen. So I'll put the first poll question up for everyone to read and to reply to. You can see it on your screens now, I believe. So the question is, will you retain a Vietnamese local law firm to advise and support the Vietnam formality requirements during the arbitration proceedings at a foreign arbitration center to ensure the high possibility of enforcing in Vietnam at the latest stage? Right, there you go. You should be able to see the results on your screen.
Yeah, I agree. You should have a Vietnamese local law firm to advise and support you on the formality requirements, because the understanding of the formality requirements in the common law system and in the different jurisdiction maybe have the gap. So the best advice should find the local law firm to advise you on the formality requirements, particularly who has the real experience in litigation at court.
Thank you for that. And now I'll share the second poll on the screen for everyone to answer. You should be able to see it now. So between arbitration proceedings and court proceedings, which one do you prefer for settling in the case of a commercial dispute? So is it international arbitration, Vietnamese court, or you consult with a Vietnamese local litigator before making that decision? There you go. You can see the results on your screen now.
I prefer the answer 3, that you should consult with your Vietnamese local litigator. The reason why, some situation, international arbitration is good, but in some situation, Vietnamese court is better. Why? Because in scale up, you would like to apply the emergency or interim measure. You ask for the interim measure to prevent the damage against the opposite side. But only the Vietnamese court has the power to consider for apply the interim measure. So even you ask for the interim measure at the international arbitration, and then the international arbitration must file the application to the Vietnamese court for the consider the interim measure. So it's waste time and E&M for sure. The Vietnamese court will not accept. Almost around 90% of the interim measure request from the International Arbitration Center rejected by the Vietnamese court. And another point is that some dispute, you should consider about the strategy of the dispute. you should see in the end what you get from the dispute to decide whether you should select the arbitration or you should select the court to settle the dispute for you. Which is better in the end? You should look at the result. You must estimate the result in scale of the dispute to select whether the court or arbitration has the jurisdiction. And I know that some party they may make the dual system, like for this dispute they will refer to the international arbitration. For this kind of dispute they will refer to the court. This seems maybe very smart, but in the end they don't. It's lack of experience at the court, and the Vietnamese court will not accept this kind of provision in the commercial contract. The Vietnamese court, if you make this kind of dual system, the Vietnamese court will reject. Instead of you fight the dispute at the Vietnamese court, they will reason that in the end, what you want, who will settle this dispute for you, arbitration or the court. At this stage, the Vietnamese court will reason that it's unclear because this is in one commercial contract. So if is there any dispute, it must relate into this contract. And now in one commercial contract, you separate many types of dispute, and you one go for arbitration, one go for the court. So it's unclear, and the court will reject the lawsuit. So I think I suggest for any reason, you should consult with your lawyer and to understand the whole process from the outset until the end to see what is the risk. And based on the risk, you will consider which the jurisdiction you will apply for. Because sometimes Vietnamese courts will be good for you, not always bad. I believe that the reason why the international arbitration are more referred than the court in Vietnam, I quite understand, because many people see that the Vietnamese court is backdated due to corruption and something like that. I can understand that reason. That's the reason why international arbitration is better, faster. But in my experience in Singapore, the people still refer the Singaporean court than the international arbitration. So depend on the situation. Nothing is right 100% or wrong 100%. It depends on your situation, depend on the risk you can see. You should select which is good for you. Thank you. And it's almost finished the time for my presentation. And thank you for your joining. And if you have any question, you may contact me directly from Lê Anh Trần website. Thank you for your listening.
And thank you very much, Stephen. It's been quite very insightful presentation and Q&A. I believe we had somewhere around 6 or 7 questions coming in from the audience today. So it's a very important topic for our attendees today. And I've shared Stephen's information, his phone number and his email ID in the chat function. So if you have any questions for him, as he mentioned, you can get in touch with him directly. If you need a copy of his slides, or if you just need any further information, or if you are in Vietnam and you would like to catch up with Stephen for a coffee, please email him and call him directly. I'm sure he'll be very happy to speak to you and to meet with you. Right. Again, thank you very much, Stephen, for participating in the Vietnam In-House Community eCongress. And I hope we can do this again in person in 2023. With that, thank you very much. Have a great day. And hopefully we'll see you in person in 2023. Goodbye.